Hey guys, I'm Jacob Blizzard. I'm a board-certified criminal law and criminal appeal specialist attorney practicing out of Texas. Today I'm continuing to talk to you guys about the 2255 motion to vacate judgment or writ of habeas corpus in federal court. If you have a loved one incarcerated in federal prison, this applies to you. Your loved one and you should be pursuing this relief as soon as possible because the timeline is running. If you haven't watched my video on the timelines involved, make sure to watch that video. It's very informative about how fast this process goes. When you are doing this on your own or you're looking to hire a lawyer, whatever you are thinking about doing there, you need to act fast because the timelines run very quickly. And today I just want to emphasize that and talk to you about what is all happening in that time and how you can prolong that timeline. So, when we're hired to do a writ for someone, whether it's a state writ or a 2255 federal writ like this, there's a whole process that goes into it. And so whether you're doing it on your own or you're hiring an attorney out there to do it, there's a process that you have to go through to even get you ready to the point to be able to prepare the motion itself. You have to gather the records. That's the first thing you want to do. You want to get a copy of everything that your trial counsel and appellate counsel, if you had appellate counsel, you want to get a copy of everything in their file. Send them a letter. Says, I want a copy of my file. Please send it to me immediately. And get that copy so you can start reviewing what they had in front of them to see what mistakes they may have made in their representation of you. You also want to get a copy of the government's file. Now, there's going to be some restrictions. You can't just write to the government and expect them to hand over everything, but you can do public information requests. You can request records from federal agencies that may have been involved, state agencies that may have been involved in the investigation or prosecution of you. You can go to those directly, and you can do open records requests to the U.S. Attorney's Office or Department of Justice entity that was involved in your case. The best method to get most of the things you're going to find in the government's file, though, is through the defense attorney's file, because the defense attorney will have had all of the police reports, the body cam footage, the interviews, the witness statements, all of those things. That's the very first thing you want to do when you're looking at pursuing the federal writ process here. Then you're going to comb through those records. You're going to be looking side by side on that defense record and the prosecutor's record. What do I see here that just doesn't look right, doesn't feel right? Am I seeing ineffective assistance of counsel, something the lawyer should have done that he didn't do, or that he did that was wrong? Or am I seeing some Brady material? That's exculpatory things that happen that would have shown I was less likely to be guilty. They're in the prosecutor's file. They're not in the defense file. And so it's more likely that I would have been found not guilty had this person provided that information. That's a Brady violation. Is there some due process violation? The third record you want to get is you want to get a copy of the transcripts in the clerk's record. So the clerk's record is going to be all the motions and filings that were in the case. So you're going to get a copy of the indictment, the charging instrument, the motions that were filed in the case, the discovery motions, the responses, the motions to suppress, everything like that, all the orders of the court, the pre-sentence documents, the pre-sentence reports, objections, responses, addendums, all that. You want to get all that. That's all from the clerk's record. You want to also get a copy of the transcripts in the case. Now, if your case didn't go up on appeal, then your case likely was not transcribed. But if your case went up on appeal, you should be able to get those transcripts from your appellate attorney. If your case didn't go up on appeal, you can order those transcripts from the court reporter that was involved in taking the plea or resolving the case to your case. And so, again, you want to act fast because you got a lot of things to go through here and you only have the 1 year to do it. So the last thing I'll leave you with is there's always a benefit to prolonging the process of your conviction being final as long as possible to give you that extra time to try to pursue the 2255, because you can be gathering those records, you can be working on identifying issues as you're going along in the appeals. Everyone can appeal your conviction, even if you pled guilty. Maybe it's dismissed as frivolous, but you can file it an appeal in every case, and that's going to buy you some more time because your conviction isn't final until the appeal is resolved. And so that may buy you another 6 months, 9 months. So then when that is resolved, then the 1 year starts. So you want to prolong that process as much as possible if you can. And to the extent you think you may not have a valid appeal, you can pursue it with a court-appointed attorney, or you could do it on your own. That may be that the court-appointed attorney or whoever it is winds up filing the Anders brief, but they're obligated to do that, to look at the case to see if there's any appellate points that could be asserted. Even if you waived appeal, you can still pursue the 2255. I'm going to talk to you about that in another video, but be diligent in pursuing your rights because the federal government does not want to give them back to you. So be diligent, pursue it. If you have questions about this video, feel free to comment below and watch our YouTube channel, download our guide. Thanks for watching, guys. We appreciate you. Take care.